Продовжуємо засідання.
The session continues. Please invite Madam Iryna Vadymivna Kuzina to the room.
Доброго дня.
Добрий день, Рада комісія.
Hello, dear Council and dear Commission. We are considering the issue of compliance of the candidate for the position of the judge of the HSC, Kuzina Iryna Vadymivna, with the part 4, Article 8 of the Law of Ukraine on the High Council Anti-Corruption Court. We have the following PCIM members: Robert Heinbrock, President Chair of the PCIE, Mary Kay Butler, remotely, Yudkaita Grinskini, Norman As, remotely, Jessica Thompson, John Sullivan, and also the HKCJ members who are present here. Руслан Мельник, Олексій Омелянов, Андрій Пасчин, Руслан Сидорович, Ірина Лопушняк і Руслана Шевчук. You have the right to submit recusals, submit motions, concerns, suggestions upon agreement of the presiding chair. And do you have any recusals? No, I don't have. And we have Melnik Ruslan Ivanovich, the commission member, who is the rapporteur on this candidate. Thank you. So, Iryna Vadymivna Kuzina, I will start my presentation of the candidate. She has graduated from the National University Yaroslav Mudrylo Academy of Ukraine and received specialist in law degree in 2005. Regarding her professional activities, starting 1st July 2005 to April 2006, she worked as an investigator in the Department of the Southern Railway of the Ministry of Internal Affairs of Ukraine. Then she worked since July 2006 to June 2007 as legal advisor of the law firm Perimoga, and then she worked as first deputy director of the law firm Perimoga from June 2007 to May 2008. Since September 2008 to December 2019, she worked as a lawyer in the company Agrotrade. Then she worked as an individual entrepreneur, and starting 2014, she was the director of the Iryna Kuzina law firm, and then she was also an attorney at law at the law firm Ilyashov and Partners from 2017 to 2018. Starting August 2018 to March 2021, she worked as attorney at law, independent professional activity, and since 2021 till now, she's attorney at law firm Shadrin and Kuzina. So this candidate has an attorney's experience, including in terms of representation of interest of clients in courts, not less than 7 years, and she is proficient in the state language. The candidate has submitted 3 declarations: family ties declaration, integrity declaration, and declaration of a person admitting for the position, applying for the position of a judge. During this competition, we have reached out to relevant public authorities regarding this candidate, and we have received no negative information regarding this candidate, which could confirm any non-compliance of this candidate for this position. We have also sent separate request to the Bar Qualification Discipline Commission of the Kharkiv region and the Kyiv region in order to provide information regarding potential disciplinary proceedings and bring into disciplinary liability for the attorney Kuzina Iryna Vadymivna. And information was received that Madam Kuzina was not brought to disciplinary liability. This is all from my side. Can I add information? Yes, please. Over to you, but please be concise. So just a small clarification. I sent an application that since 2018 to 2023, I had cooperated with barristers law firm. If there is any question related to conflict of interest, it shall be taken into account. That's all. Can I clarify what the conflict of interest is about? I don't know what questions could be asked to me as an attorney regarding different clients. It's just information that I have provided to you because at the NABU report, I didn't see this information. So it underlines that my husband is a partner and I had worked on several legal contracts till 2023 with them. Thank you.
Пане Роберте,
Mr. Robert, over to you.
будь ласка.
Please.
Thank you, Mr. Chairman. I believe that Mary Butler is the rapporteur in this case. Mary, the floor is yours.
Thank you. And good morning, Ms. Kuzina. Thank you for your cooperation in this important process. I want to start by noting that you have applied for both a local court judicial position and the High Anti-Corruption Court judicial position. Please explain why you want to be a judge now and why in particular the High Anti-Corruption Court.
Добрий день ще раз.
Hi again. So as an attorney on criminal cases, I wanted to keep working at courts, specific courts of criminal specialization. Earlier, I didn't have such plans at all to be a civil servant. But when I saw how procedures take place, how happen they, I saw that they are quite transparent right now. I thought that, yeah, it's an opportunity for me to change the profession. I was thinking about, I was observing other competitions, and I realized that I could give it a try. Specifically, that before the announce of this competition for the competition of the courts of first instance, the HKCJ actually called for attorneys in particular and other legal practitioners to apply for such competitions because at such courts we have deficit of judges, and that's why I applied for the competition in courts of first instance. Hoping for criminal cases, criminal specialization. But at such courts, criminal specialization is not a guarantee, and the decision what a judge is going to work at on criminal cases or civil cases, it will be decided by the Congress of Judges if there is such a specialization at a specific court. But when the competition for the High Anti-Corruption Court was announced and based at the taking into consideration the previous results of the previous competition, when there was a deficit of judges, I decided that I may also participate in this competition. As a minimum, I will support the process of the competition because, even if I'm going to be an attorney further, anyway, I'm interested for the High Anti-Corruption Court to be composed of qualified independent judges. And independent judges is also a very important notion today. That's why I'm here to offer my services, so to say, to offer my resources. And I rely upon the discretion of the Council and the Commission, which could define my place at the judiciary. If it happens, I plan to work at the judiciary till the age of 65 years, if my health allows me. At which position? Of course, I would like to grow myself. I would like to grow till the level of the Supreme Court, but now I'm not ready for that. But theoretically, if there are such issues, and if I'm potentially appointed as a HEC judge, and then the competition is announced for the Supreme Court, I would not participate in the nearest time, because, you need to work first at the current place of appointment. I think that's all for now from my side. That's regarding these two competitions. But I don't know whether shall I reply also regarding other questions regarding this court.
Thank you. You mentioned that you were affiliated with the firm Barristers from 2018 to 2023. And I know from your application you were previously involved with another very active firm in criminal defense work. I want to ask some questions about the impact of your experience as a defense lawyer in corruption matters. First, were you yourself involved in matters that involved the NABU and the Special Anti-Corruption Prosecutor's Office as a lawyer?
В Вищому антикорупційному суді
At the High Anti-Corruption Court, the appellate chamber, I had a case.
360
Article 369.
Прокурор був підзахисним.
Prosecutor was the defendant.
Пропозиція на правомірної вигоди.
There was a suggestion for illicit profit from one prosecutor to another.
Далі в апеляційній
Then,
Вищого антикорупційного суду.
At the the first case is that now at the appellate court, and I participated at the first instance at the appellate chamber. I defended the judge of the first instance, Article 368, Part 3. That's regarding suggestion for receiving an illicit profit. And actually, regarding the preventive measures, Article 191, Part 5, but it was only regarding selection of the preventive measure. Then I didn't participate in that case. I think it was related to illicit appropriation of property of another person. Maybe several times I participated in interrogations and I visited the NABU, where interrogations took place. They are usually called separate procedural actions. Regarding the High Anti-Corruption Court, I can't say that I'm engaged very often in cases considered there. And I have general corruption offenses in general courts. That's part 5 of Article 191, specifically related also to extremely huge amounts, or when it's about abusive usage of funds, or it was under another case under Article 362, I think, Part 2, receipt of receipt or acceptance of an offer. I don't remember specific details. Receipt of an illicit profit and abuse of powers. I can't say that I'm exclusively specialized at anti-corruption issues. No, I have a wider criminal specialization, but the white-collar crimes, that's indeed what I handle.
I'm sorry, you said white-collar crimes is your specialty, is that? I'm interested in whether there is anything about your direct experience with the NABU or the Special Anti-Corruption Prosecutors, or appearing before the HAC, that you think would make it difficult for you to be fair and impartial in judging the conduct or testimony of NABU representatives or the professionalism of Special Anti-Corruption Prosecutors?
I would clarify that I have a broader criminal specialist than white collar only. And with respect to, that's just a clarification. And with respect to your second question, basically, no problems or conflict or any situations with employees of the NABU and SAPO have never been in my life. No. Once I submitted an application during the court hearing. There were no other procedural actions outside of the court hearing. And I said that one of the prosecutors violated Article 3 of the European Convention of Human Rights with respect to my client, and I submitted this motion during the trial process. There were no other further procedural actions like submission of a disciplinary complaint or some other applications of on criminal offenses. That was the position of the client, not to do that.
And I noticed that your husband has also been at least a member of the barristers firm. Is there anything that you are aware of about his experience with the NABU and the SOP and appearing before the Hague court that would negatively affect your ability to be fair and impartial in cases appearing before you at the Hague?
My husband is even less. He is even further away from the corruption sphere. He has a more general criminal specialty. He has very sporadic cases in the Hague under Part 5 of Article 191. That's the case that he has now. I've never heard about his conflicts or any statements regarding violation of his rights by the NABU and SAPO. And I think that the case that I've just mentioned that he has, and I think he entered this case at this, if I'm not mistaken, he entered it at the stage of the trial proceeding. I think he has, he told me that he has Article 209 in his work, in his caseload. That's legalization of illegal proceeds. And I'm not sure, maybe it is at the stage of the pre-trial investigation, but as far as I understand, everything there is fine in terms of the working mode. And just in case, I would like to mention that regarding clients of my husband and regarding clients of barristers, attorney at law company, I will have a conflict of interest, so I would not consider that.
And would you say the same about clients of Ilyashev and Partners? Your former employer?
No, with respect to clients of Ilyashev and Partners, in Ukraine, we have two types of response to the conflict of interest in terms of procedural actions. If, for example, I saw an attorney from Ilyashev and Partners whom I do not know, who would present interest of clients with whom I have never worked, then I would consider that as a ground for the notification that I used to work there. With respect to Ilyashev and Partners, of course, I have a conflict of interest in case of those clients with whom I could work. I did not have that many of them because I am the criminal practice attorney who is not, for example, preparing agreements for many clients. As a rule, the criminal case envisions fewer number of clients. And that's why that's the situation.
Thank you for that clarification. I do want to ask you some questions about a matter which occurred in 2019. And I'm particularly interested in I'm particularly interested in your role in connection with this matter. And this has to do with the situation where the High Council of Justice filed a submission to the Qualifications and Disciplinary Committee of the Bar of Kyiv to hold you and others to disciplinary liability involving alleged interference with the role of the court in the Fostier City District Court in Kyiv. And in particular, can you explain your role in that episode and also what the outcome of the hearings before the Qualification and Disciplinary Committee were for you?
Thank you for your question, because right now I can for the first time publicly comment on the decision of the High Council of Justice. I believe that the procedure that took place has some shortcomings, maybe procedural shortcomings, because I got a decision to which I would like to draw the attention of the public, but I have never taken any part in its adoption. I will clarify. In 2018, starting from 7th to 9th of August, there was a hearing regarding 4 motions on extension of interim measures in the form of detention in the case on violent murder, part 2 of Article 115. Previously, I did not have this case in my proceeding. There were 2 attorneys that you mentioned, Shadrin and Hella. Previously, they were the attorneys in this case. Since Shadrin was feeling unwell, he was on sick leave, and that is mentioned in the decision of the Qualification Disciplinary Commission of the Bar that I have provided day before yesterday. Did you receive it along with yes? So, he was on a sick leave. He could not drive. And that's why the 3 of us, we lived more or less in the same district of Kyiv. That's why the 3 of us used my Toyota Corolla vehicle to the court. Initially, I was a driver, and it was a week since I resigned from Milashev and Partners. I had time, and I wanted to see the case. But it turned out that I had to enter the case because Hella and Shadrin were defending 2 persons who had the status of the perpetrator and accomplice, father and son. The case was very high profile. About 40 athletic men were nearby in the court vicinity. Some of them were in militarized clothing. It was August the 8th. We knew from the attorney of other suspects, because there were persons 3 and 4 as well in the case. We knew that before the 7th of August, the attorney had 2 of his tires slashed, which makes it impossible to repair the car quickly. So, upon arrival to the court, we passed the court building and we went to the prosecutor's office to leave our car there, hoping that it would be under camera surveillance. We entered the court building. In the decision of the Qualification Disciplinary Commission of the Bar, there is a very detailed description of the process. I do not remember all of that, but they have references to technical recordings and logs for the court hearing. And the court hearing did not start on time because of the failure of the prosecutor to appear, and not because of the failure of the attorney to appear. Then the client one felt unwell. He required medical help. The court hearing started, and the first thing that a new attorney has to do is to get acquainted with the case materials and to at least get a very brief confidential meeting with the client in order for the client at least to agree that the attorney would represent the client, at least to nod to the legal position. We understand that the deadline was very concise, but in violation of the right for defense, the judge refused to provide this opportunity. That's why we had to take measures of response, how attorneys should do that. I explained that I have experience of working in the free legal aid system. I know this algorithm of actions very well because I had experience with separate procedural actions. There are quality standards of free legal aid in criminal proceedings available, and all of them require familiarization with materials and a confidential visit. I will not quote requirements of the Criminal Procedure Code. So, I was acting in the interest of clients and in line with the law. Unfortunately, it was not perceived by the court, and the process took place as it took place. The court hearing, and it's necessary also to understand that the judge was hearing either 2 or 4 motions, I don't remember specifically. So, one suspect was entering, then leaving the other one. So, indeed, the judge had lots of work in 3 days. And that was the father and son. And the High Council of Justice is mentioning that decision, and as far as I remember, the judge submitted that notification. And I would like to emphasize again that the crowd of activists was entering the closed court hearing. They were trying to get into the court room. During technical breaks, they surrounded Tony Hella, and I sent the video how they demanded to refuse to provide defense. The crowd did not perceive the very existence of attorneys for these defendants. I don't know how they thought that the process should take place. And that was the atmosphere, quite difficult atmosphere, and we had to work in it. When we left at about 4 a.m. at night from the court building, we reached the car. It was very dark, very hostile environment, and we saw that 2 of my tires were slashed on my car. It was 4 a.m. and we had an appointed court hearing for 10 a.m. So at about 5 a.m. we reached Fastiv railway station by foot. We took a train, reached Kiev. From Kiev, I had to take a taxi to my place of residence in the region, and we had to go back because Shadrin needed to have injections done. He was getting antibiotics injections, and using his car, Seat Ibiza, we loaded the tires and we went to the court building. Of course, we were late. And during the round of questions, you asked whether we notified about this being late. On the case of materials, there is a protocol of this phone notification. So there was nothing about that. Also, I do not know whether all Commission members have looked through the decision on denial in initiating of the disciplinary case with respect to Shadrin. And with respect to me, as far as I know, the HCJ did not send anything anywhere, even though there was a decision to notify it, but the letter was not set in fact. So I was not brought to disciplinary liability regarding these circumstances of the case.
And on this question of whether you had advised the court that you would be late, can you tell us whether there's a record of that communication to the court? As I understand it, one of the issues was an allegation that you simply showed up late without advising the court that you expected to be late and why.
The only means for provision of swift information to the court, it was make a call to the secretary of the court session, and this call was made by Mr. Shadrin because I was driving, and of course it was impossible for me to call. So he called, he informed the court that both of us are late, and I'm driving, that's why I can't speak, and this all information is related not only to him but also to me, and he also he informed about the reason of this delay, that the property was damaged, which should have been used to get to the court. And this is information on the page 115 of this proceeding. Now I'm speaking about the document, which is called the decision of the Bar Qualification Disciplinary Commission, page 115. You can see that based on their text, they were referring to some evidences provided. So it means that this protocol shall be, the original of this protocol shall be archived at the court.
So it's my understanding that there was some corroborating evidence of the call to the court as you were trying to travel there. Is that correct?
Yes.
And what was the form of that corroborating evidence? Was there confirmation by the person you spoke to? Was there some recording of the message you left?
One of the formats to document, and I will explain again, so the secretary of the court session, and that's an employee of the court, and this is the official of the court. confirmed this fact and then produced this document. That's a protocol of a phone message. That's page 115, and this is a page which disciplinary chamber refers to.
Технічні записи.
And also there are technical notifications that the court started the session at 10:24, and as far as I understand, the judge just didn't take it into consideration, this information, and I don't know why.
Is there anything else that you think that we should consider in connection with that proceeding? Because it's obviously a significant issue that an applicant to the High Anti-Corruption Court might be referred for disciplinary liability. So to be clear, you personally were not referred, and you were not held to liability. Is that right?
ВРП не направило.
So the High Council of Justice didn't send their decision to the Bar Qualification Disciplinary Commission and its disciplinary chamber. The disciplinary chamber didn't initiate a proceeding and didn't make any decision regarding bringing me to disciplinary liability. What else? And also, just in a nutshell, I would like to dwell upon the aspect that allegedly Shadrin was trying to forcefully enter the deliberation room, and also in this Bar Qualification Disciplinary Commission decision, it was rebutted. So when attorneys enter the court and they don't know what court room their case is being considered, usually they enter into the reception room of the court building. As far as I remember, Shadrin informed me that yes, in that court there is a specific reception room where the secretary and assistant shall be, and then through the doors there shall be another room of a judge where it could be deliberation room. Anyway, there were no names on the doors, no plates on the doors, and that's what has happened. So the advocate just approached that room to clarify the number of the courtrooms. It's a normal practice.
And just to clarify, this person, Shadrin, this is your husband. Is that correct?
На тепер так.
As of now,
На
yes.
той момент
At that moment, we have lived together. At that moment.
And are there any other instances where allegations have been made against your professional conduct by any court? We've talked about this instance in Fastiev City District Court. Have there been any other instances in your career where a judge has referred allegations of misconduct by you to the High Qualification Commission? High Council of Justice, sorry.
Судді ніколи
Judges never referred to HCJ or Bar Qualification Disciplinary Commission. For my whole professional history, I had only one application. I think it was back in 2014, and this application was submitted to the Bar Qualification Disciplinary Commission in the Kharkiv region. The procedural opponent in the civil case was not satisfied with the legal position expressed at the court from my side and from the side of my client. At that moment, we won the case, and the disciplinary chamber didn't even open the proceeding because it's not allowed, it's not accepted to intervene into the legal position of an attorney, to interfere with the legal position of the attorney.
I'm sorry, so there was, back in 2014, a suggestion that what had happened? I'm sorry.
Дата це було
So yes, it was a suggestion. I worked in the city of Kharkiv at that moment. It was roughly. I just know about it because I provided explanations on that matter, but it was even before the opening of the proceeding, and the Bar Qualification and Discipline Commission refused to open the proceeding. And when, I don't remember when I answered on this question, I think it was the integrity declaration, I marked relevant lines. So there was a question whether anyone have ever submitted any applications to any authority, and that's what I meant there.
Okay, I'm sorry. I don't know what type of application you're referencing. This is one related to your conduct before the court?
До дисциплінарної палати.
So the disciplinary chamber of the Bar Qualification and Disciplinary Commission, that the Bar Authority received an application from a procedural opponent, a citizen, not a lawyer. Using his just own words, he expressed his position that he doesn't like my legal position in the court, that I shall be brought to disciplinary liability, that it's not allowed according to provisions of the law on bar and advocating activities. And of course, in such a case, the disciplinary proceeding was even not open.
Thank you. Now, I have some questions about other aspects of your conduct. One, we note that you traveled to Crimea for 2 days in 2018, when, of course, Crimea was controlled by the Russian Federation. And I wonder if you can explain. We understand that that was supposed to be for a meeting that you were having with a client, but I wonder if you can explain why the meeting had to take place in territory controlled by the Russians as opposed to somewhere else.
Я прошу вибачення, у вас неправильна інформація.
I'm sorry, you have wrong information. I didn't visit the Crimea since 2014, since the moment of occupation of the Crimea, when I was working at the Kyiv branch of law firm Ilyashov and Partner as an attorney. And at the document, it says that it was a business trip for 3 days to Moscow, where the Moscow office of Ilyashov and Partners law firm was located. What I can mention without violating advocates' secrecy notion, that I needed to report to a very big client from Kazakhstan. Why in Moscow? Because the office of the firm is there, and at that moment it was both the report of the Moscow office and in my and on behalf of the Kyiv office, I presented also the report. And it's also because of traveling reasons. To fly to Kazakhstan, it was closer to distance to fly to Moscow rather than I don't know where this client was. So, and it's also, if it's comfortable for a client, their wishes are taken into consideration. But again, I need to say that I was not responsible for provision support to this client. One of the partners was responsible for that client, but that client at that moment was banned from entering into the territory. I don't know why, what was the reasons, maybe some political exclamations or what, but as there was one big case, one big transnational criminal case involving this client, as that's my specialization, I was provided with information, with report. So as a lawyer on the criminal cases, I also was capable to answer swiftly on any ad hoc questions regarding procedures. As at that moment, I was exclusively specialized at the criminal cases. I mean, apart other attorneys, and I don't count here partners, because other attorneys at that moment, at that law firm, they had also other specializations on civil cases or so, commercial cases, and criminal cases was exclusively of my specialization. So I was assigned to go to that business trip, and I received this order from an employer, and I fulfilled it. It was a legal order, and it was legally allowed to cross the border. I didn't even spend a night in Moscow. I spent a night in train. So then my employer ordered a taxi. I took a taxi, arrived to the office. We worked there during all day. I had some cup of coffee, chocolate. I didn't even leave the office premises. Then I was returned back to the railway station. I didn't have even Russian money, Russian currency. I had only dollars with me if I needed anything to exchange, to buy something. But I didn't spend any single cent there. The employer fully covered my expenses. I had so much work that I didn't have even time to go for lunch there.
And just one clarification, did you say that the client was barred from entering the territory of Ukraine?
No, not the territory of Ukraine, but so it's not the client. So one of my heads, one of my supervisors was banned. So from to enter the territory, and at any law firm, we have a person, a manager, who is responsible for provision support to a specific client. So in this case, one of senior partners was responsible for this specific client, but he was not allowed to enter the territory of the Russian Federation. That he was not possible for him to go. That's why I went.
I see. So he could not travel to Russia. I see. Now a few more questions about reporting on assets. I know that you have answered some of these questions in writing to us, but I want to be sure that people online have an opportunity to hear your responses. Specifically, you did not report any resources used by you to support your minor son, and can you explain whether or not you, in fact, did provide support for him, and if not, who does?
Do you mean my second son? No, I just didn't receive this question, so please clarify this question for me.
My understanding is that you have a son who resides in Germany.
So
I don't know how this information could be confidential because it's related to a minor. So if it's possible, if you have a question regarding this part, I'm asking for a closed part of the interview.
Well, does anyone besides yourself provide financial support for the minor?
1 second, Mary. There is a request of the candidate to close the hearing on this subject.
У нас наступна практика в такому випадку.
Dear colleagues, we have the following practice in such case. If a candidate submits a motion for having a closed part of the interview without broadcasting, so first we shall suspend the broadcasting and clarify in detail the reasons of a candidate to submit such a motion, and then we consider a motion itself. So if now we have such a motion, I suggest to do the same. It's a closed part of the interview. We can clarify the reasons why the reasons were, what were the reasons for such motion, and do we satisfy it or not? And then we either satisfy the motion and have a closed part of the interview, or deny in closed part of the interview. So, do you insist on having it?
I have a suggestion. How about if we go through the rest of the questions and come back to that one. Is that
I think-
maybe more efficient?
Так, звичайно.
Yeah, of
Так,
course.
звичайно.
Yes, of course.
Okay.
Is that okay?
Yes, we agree.
Okay.
You can ask questions.
Oh, thank you. It's my understanding that in the official register regarding your official income from 2005 to 2019, it's quite low. And yet you were employed as a very active lawyer. Can you explain how that happened and whether you have clarified your income sources?
Ну, я намагалася відповідати
So
на
I
питання.
tried to answer to all questions as much as possible, and I'm sorry, as I don't have all primary documents with me right now, but maybe I would miss some things. But
В загальних рисах за 2005
generally speaking, for 2005-2006, I explained that the salary was not reflected, which I received as a police investigator in the Internal Affairs Authority. So it could have not been reflected in the reports because of the nuances of the accounting procedure. 2006 to 2008, when I worked at the Perimoga law firm, indeed, I started with a very low salary. I remember very well how much it was. It was 500 hryvnia per month, and it was less than $100 per month at that exchange rate. And I agreed to work for such salary in order to gain some legal experience, because, you know, it's quite hard to find a lawyer's position in Kharkiv without having any experience at all at this field. And indeed, I started with that position. But starting third quarter 2007, I received an increase in salary, and I think that that's the employer who failed to reflect all salary data at that moment. I remember that it was higher. That's why when I asked whether everything was reflected at the data and the system and registers, yeah, I think I said that I reflected, but I cannot confirm it. So it shall be reflected higher. But then somewhere 2008 and almost till September the same year, I had been looking for a job. In 2008, my first marriage was dissoluted, so I divorced. My parents supported me. At that moment, my child was 4 years old. My first husband has never paid any alimony at all, no alimony payment at all. And that's why my parents at that moment, starting that moment and further, have been supporting me. And as his father didn't maintain communication with his son, so my parents have been supporting my son. So even now, when I have quite high income, my parents keep providing support to my first son. Then I started working with Agrotrade. First, salary was reflected in a correct manner, but then you can see that there was a reduction in salary. The reason was financial and economic crisis. And I think that reduction was not that drastic as it was mentioned, and it was mentioned two and a half times. But I remember that the reduction was by 20%, not more. So it was maybe a reduction by 500 hryvnia, by something like this, but not by 2 times. I understand that the Commission and the Council may not like this information, but I'm open in answering your question, and I take all responsibility, all consequences of myself. Since 2010, I was a private entrepreneur. The code 69.10 activities in the legal field, and I was under unified tax category. And my private entrepreneurship was enforced till 2016. I don't remember when I specifically stopped providing those activities, but I think that when I started working at the law firm Elastic Partners, at that moment I stopped using my private entrepreneur status, but I don't remember the turnover at that moment. And usually the reporting is made regarding the turnover, not the profits received. And as far as I understand, in that register, you will not have this information. It shall not be there. Then, starting 2010, my private entrepreneurs' activities were carried out. And you can see that I have received some revenues from different legal entities, but at the same time, taxes from income of individual persons were not accrued. So it happens when payments are made at the bank account of a private entrepreneur, not an individual person. But we don't see any details. We see only a general amount of profits. So, to my opinion, this part of the register doesn't contain full information. Then, because of the birth of my second child, I stopped working in 2016, 2017, but I didn't stop my practicing law, but when I was pregnant, I was not capable to take new cases. I had quite a few cases related to Kharkiv Polytechnic Institute, where I represented one of the ministries, and it was a range of commercial cases and one administrative proceeding. Those cases were ongoing, but at that moment I was pregnant, and I helped with those cases. I visited court hearings when I was pregnant and when my child was so small. So I kept providing different service activities, but at that moment I didn't take new clients. And when there are no new clients, no new cases, you have no revenues, you have no income payments, and you cannot declare revenue because you didn't receive it. And then that's why that period of reduced my work and income was related to my family circumstances. 2015, first half of 2016, I have concluded an agreement with the system of pro bono legal aid, and at that moment, I believed that the advocates' activities, attorneys' activities, it's not about entrepreneurship, but it's about protection of human rights. And also at that moment, I wanted to gain experience of criminal cases. That pro bono legal aid system, they provided trainings and learning activities, very good learning activities. At that moment, their reputation was very high. And after...
Sorry, could you please explain in financial aspect? Yes, the contract was concluded with Shadrin Kuzina law firm. What was the financing of the free legal aid? We all know. And it happens that I had two budget programs, that is a free legal aid system, and Kharkiv Polytechnic Institute. These are budget allocations. So I relied on budget allocations. To put a high salary for myself under these conditions, I cannot do that. So when I had the locations, they were transferred to the individual entrepreneur's account, as far as I understand. So you can see the salary. I think that something was at the individual entrepreneur's account, but I was working more to gain experience. And back then, I was married. I have not mentioned that, but my husband was Kuzin. He worked, and I was working just to develop my reputation, which happened to be effective in mid-2015, when I was not looking for a job, but I was invited. I got employed by a very good big firm. So I believe that these were sort of investments into my future and into my career. But the first half of 2015 and 2014, when I was working in the free legal aid system in Kharkiv, I can tell you in more detail what that means. and how that works. But back then, I did not have significant income. Even if you are working full time, and even if you're accepting all the orders from this center. So that was the situation. Not always I work for the sake of the profit. Back then, I was working for the sake of my reputation and to gain experience.
And if I could focus your attention particularly on the years 2018 and 2019, which, as I understand it, were years when you were employed as an attorney with the law firm Barristers. The reported salaries are 1,350 hryvnia and 131 hryvnia. Can you explain?
Я зараз передивлюсь, тому що я пам'ятаю інші.
I will double check because I recall other figures.
Mary, please look a bit at the time if you can do that.
Це неправильна інформація.
That's incorrect information, inaccurate. Until the 31st of July of 2018, my salary was with Ilyashev and Partners. After that, yes, my income decreased, and I can explain why. I resigned from a big firm at a new place. I was transferred within the framework of this firm from one town to another town, and I had 0 clients as a result of that transfer. And it was envisioned that I would cooperate with Shadrin and with Barristers law firm, but back then Barristers was a startup. They also, maybe in 2017 or in 2018, they were only established. And in connection with that, they got different awards like Breakthrough of the Year, Launch of the Year. But in order to have the client base, they were quite aggressive in their tactics. But also effective as well, because for one contract with client, 5 attorneys were working on that. And at first I had to cover my expenses, because if I started outside of a firm, then I would not be able to afford an office in Kyiv. But when you're working in a team, you have to jointly cover these expenses. So in 2018, I did not get profit as such, but I was gradually working. And in 2019, I learned about my pregnancy, and in November, I gave birth to a child. And again, I continue practice when I'm pregnant, but I cannot take complicated criminal cases, new ones. I decrease my workload, and I continue working only on those cases that I had in my work, because I have commitments to my clients, and I have commitments regarding uninterrupted defense of my clients. So in 2019, I was sort of on maternity leave. And only in 2020, I started taking cases because I had an opportunity. It's impossible to plan the situation allowed. And starting from 2020, I had quite an extensive case.
Okay, in light of the time, I just have that one question for which you asked for a closed hearing, and maybe there's a way to handle this more efficiently. Has anyone unrelated to your children provided support for their education, tuition, residence, food? Anyone unrelated to your children provided financial support for them?
Так, давайте.
Okay, let's, with respect to the minor child, I can disclose that in open hearing. In Monobank, there is such a form as child's bank card. It's connected to my card. If you saw my bank statements, you can see the flow of funds, and some expenses are from child's card. And by the way, they can be reflected in another region because from Ukrainian banking card, people can pay in other regions. I would like to address you again, please. The question is only about financial transactions. It's not necessary to explain how the monobank works. No, I'm just trying to explain in detail. We are limited in time, unfortunately. No, other no.
Okay. That is all I have. Thank you.
Yes, thank you, Mary. Further questions on this side? No, thank you. It's over to you, Mr. Chairman.
Дякую. Руслан Іванович, вам слово.
Thank you, Ruslan. The floor is yours. Thank you. I will start from a simple one, and in my opinion, the most obvious question. Tell me, please, what is your attitude towards salaries in envelopes? So to say, this black-gray salary, negatively. Have you ever received such salary in envelopes? I've said yes. Okay, so I will not lie. Okay, not to take too much time asking about all the stages of your professional life, I will quote partially from your explanations. I have worked in law firm Ilyashev and Partners, which is a leading company in Ukraine, which has leading rankings in international national rankings, has high hourly rates. According to my estimates, I got competitive salary which complied to the salaries in this body. The salary in this company was completely enough for my life. After resignation, I had financial savings for a couple of months. At the same time, NDAs do not allow me to inform about the amount of salary in this company. An external reasonable observer can make respective conclusions on their own. Thank you for your trust, that you believe that we can make such conclusions. I believe I consider myself to be reasonable and the one who can make these conclusions. So, the only thing, do you think that receiving salary in such a way complies with the current legislation of Ukraine? Overall, as a phenomenon, no, not compliant. The only thing is that the responsibility is on the employer, as the employer who is breaching labor rights of the person, as well as on the tax agent who has to have the respective accounting. But I don't know whether you will ask that or no, but now I would not agree to that. Okay, should I ask you whether you know how taxes are spent? Taxes deducted from the income that you actually received, but formally they were not declared anywhere. And accordingly, they were not taxed, not registered, not accounted. And accordingly, there were no transfers to social commitments of the state. Do you know, should I ask you how taxes are spent? Of course, you should not ask me that. I know that. The only thing that I will explain maybe to the PCAE members that it's not good, but it's a prevalent phenomenon in Ukraine. Right now, the situation is better, but in the past, unfortunately, employees cannot be protected in this regard. Okay. And the same NDA, in your opinion, that the fact of the conclusion of this NDA deprives you of the opportunity to provide such information to the Commission that has to make sure that the income you received was sufficient for the lifestyle that you've just declared. I do not want to get this defamation claim. So basically, you are choosing in favor of having NDA with the former employer that you have to adhere to. But at the same time, you understand that without getting this information from you, the Commission has to use only the information that we have in the register. And if we are talking about information from the register, then your statement that you could accumulate savings for a couple of months, that looks quite doubtful, because you remember the amount that was declared during that period of time that you received from this employer? For each period of time. For the period of work in the leading law firm, 2015-18. I don't remember the amount because it's divided by quarters. I have to sit down and add it up. But the amount was not big that was declared. Great, I can name this amount if you want. So, during this period of time, from this particular employer, you received Lashev and Partners, starting from 2015, 6,000 hryvnias, 95 kopecks. No, it cannot be true. No. In 2015, salary accrued and paid by LLC law firm Lashev and Partners. 2015. There are two quarters, quarters 3 and 4. Okay, and? So please provide the information that you have. And how significantly it is different from the amount that I've just named. Regarding statements, quarter 3 of 2015, 100, 185, 45 kopecks. Probably that was not full quarter. Second quarter is set 4,910 hryvnias, and I cannot have any direct statement regarding that. The only thing is that you can check 2018. These amounts are slightly different. Yes, I've said that's the amount, 6,095 kopecks, if we add up both amounts. That's a complete year of work. Okay, 2016, to 20,091 hryvnias, and then 2017 to 24,929 hryvnias. That's annual income. I'm announcing annual amounts. These are the amounts that you officially, formally receive from this employer. And the rest that we cannot find out about because you have your NDA, unfortunately, we will not get any other information. And about these financial savings, no matter how reasonable external observers we are in this context, it will be difficult to make any conclusions or understand that. With respect to other financial periods, you've provided quite extensive explanations, and actually most of them concern the fact that the failure to specify this income in the registers is the responsibility of the employer. That's your sustainable position. No, sorry. Until 2018, I worked as an hired employee, and I do not plan to do that. Because I want to organize my work on my own. I came to this interview with the purpose of not to lie. That's why that is my priority. This phenomenon exists. Let's say that this phenomenon existed, at least in our country. And when in this life situation that I was offered to work legally, in general, and in the profession, I accepted that offer, and I could not afford to myself to lose the job at that time. Your motivation is clear. Now, going back to the episode regarding the decision of the HCJ. Again, you've explained in detail from your perspective, and you also mentioned that in a similar situation you would act the same, but just purely based on facts. let's pay attention to the fact that there was considered the matter on the extension of the interim measure. So people accused of a severe crime, intentional murder, were in detention, and there was a need to extend their detention period. Now, facts. The court hearing was appointed for at 12 p.m. on August the 7th, 12 p.m. However, upon the written motion of defense attorneys, this court hearing was delayed until the 8th of August for 10 a.m. It did not take place at 10 a.m. Accordingly, it was moved to a later hour, and it lasted until 3:46 a.m. of the 9th of August. So probably it's clear why the judge did that, because the term of detention was expiring. There was a risk that the person accused of committing a severe crime could be not in detention and without the proper interim measure, and there was a risk that there would be some negative consequences. In the opinion of the judge, who is responsible for the case that the judge is considering, and actually the matter was considered only on the 9th of August at 1 p.m. And again, thanks to the fact that the defense attorney providing free of charge legal aid was involved. So the defense attorney from the Center of Free Legal Aid was involved into the case for that. A simple question. Look, according to the Constitution of Ukraine, the bar is mentioned in Section 8, just like judicial bodies. That is in the justice section. Probably, partially, that is explained by the fact that the bar and the court are united by the same goal. The goal to have justice. They have to do everything possible for that. In this particular situation, all the details that you've informed me about, yes, that's live. And there are some attempts to influence you and the judge by those persons who were present around, and the damage of your vehicle, etc. But if we put it on the weight scales, on the one hand, we have those risks that emerged as a result of this course of events, and those efforts that you did, as you are insisting, in order to provide effective attorneys' services. Don't you think that as a result of that, unless the judge tries to involve in free legal aid system somehow to ensure consideration of this matter, then these consequences would have taken place, and even the person would have been freed, and maybe this way the justice would not have been achieved? Or do you believe otherwise? I will correct you regarding facts. The court hearing did not start at 10 a.m. on the 8th of August because of the absence of the prosecutor. On the 8th of August, the court hearing did not start because the person was not brought to the court. And then there was a motion on the change of the motion of detention of this person. Then the person was brought to the court. The person felt unwell. And in this case, you just don't know, but there is an application on torture in this case as well. The person felt unwell. The person lost consciousness, and the investigative judge made a break to find out about the health condition of the person. So the person was sent to Fastiv Central District Hospital. At this stage, I entered the case. Then, after the break, the court hearing continued at 6:53 p.m. When this person was not comprehensible in the court, and then there was clarified the issue about the health condition of this person, of the suspect. Then Shadrin at 7:03 p.m. submitted a motion following Article 206 of the CPC there was an argument with the prosecutor, then a break for provision of medical aid because an ambulance arrived at 7:10 p.m. Madam Iryna, if I provided some inaccurate information, please forgive me. We are not at the hearing of the HCJ, and we are not at the Bar Commission meeting. We are just trying to understand the situation. And from the perspective of being the fact that you are now the candidate for the position of the judge, we are not looking for guilty people. We are trying to understand whether you regardless of your status, do you correctly understand the task of justice? And imagine this situation. If you were a judge at that situation, at that particular situation, in your opinion, the actions of the judge, were they aimed at ensuring the objectives of justice? If you were the judge in that situation, would you have done something differently? In my personal opinion, the judge was under pressure and did not manage to deal with the pressure because the crowd was also attacking her. Maybe residing in this town, she was also concerned about that. I just think that she was under pressure. And my task was to overcome this pressure in order to protect the interests of my client. Regarding this case, I can inform that these persons are free right now. They perform the procedural obligations and the case is being considered. Colleagues, I think that I have to interrupt you. We have an air raid alarm signal in Kiev, so I would like to ask, first of all, the candidate, what do you think? Do you need to move to a shelter, or maybe we can just monitor the situation and assess the threat level? I suggest to monitor and continue the interview. Okay, dear members of the PCIe, what is your opinion about that? The respective channels are informing about the threat of ballistics. Obviously, it can be directed at Kiev or at any other region of Ukraine. So the threat is... Okay, colleagues, so let's continue. Representatives of the Secretariat, are you okay? Okay, let's continue. So we are continuing our meeting, and I'm asking also colleagues to monitor the situation, and if we have information about more serious threats, then of course we will move to the shelter and we will announce a break. Okay, then I will continue. I'm finalizing regarding this case. The only thing I would like to point out is that when I was talking about the severity of the crime of which this person was accused, I'm not trying to somehow identify you with the client, or no, you're the attorney, you are performing your attorney's duties regardless of the crime that someone is charged with. That's obvious and clear, and in this regard, we comply with requirements of the law. What is your position is clear. It has been explained in detail. Just now you have confirmed that, in your opinion, your actions were caused by the fact that, again, as you think, the judge was subject to pressure, lost control over the situation, and probably you would have maintained control if you were the judge.
If I may, I would like to continue. Sorry for interrupting. No. Please, imagine yourself at the role of a judge in that case. Yeah, I've just asked here this question. So what would you have done if you were a judge in that case? Given that the appropriate safety issues were ensured, I would not let myself go under the risk. So what was there? So at that moment, there was a refusal to satisfy those motions to have a normal court hearing. But we have received rejections for all motions from our side, all appropriate motions. Sorry, you're not the defense lawyer right now. You are a judge in such a case. You receive motions which you have submitted to that judge. So motions to provide a relevant, adequate time to familiarize myself with files and case files. So, there was some time, there was enough time. No, okay. So you would have satisfied the motion to familiarize with files, at least for a short period of time, because I was a new defense attorney to the case. Maybe not 3 hours, maybe less. Take into consideration that there were 2 other defense attorneys, but at least to give me some time to familiarize myself with files, because I remember that case was quite a challenging one. Yeah. So, okay, you satisfied. And then confidential meeting with the client, and then consider. Sorry, again. So, what next? So this accused person feels sick. So usually the emergency doctor shall give their exam. When did you finish? It was, I think, 9th February, so 1 minute to midnight. Now, let's imagine, 11 p.m. Emergency doctors were called. Ambulance was called. What's next? You're a judge. What will be next? I will consider whether he is capable to effectively participate in the court hearing. Okay, the pulse will be taken. Okay, the pulse is taken. You didn't have enough time to consider a motion. Then this person is considered formally free. This person can leave the courtroom free and participate as a free person. In what? In what? So in consideration of what? Sorry, yes, indeed. Sorry, it's like continuation. Then a prosecutor shall submit a new motion. And what? And to fulfill all provisions as per legislation, to ensure all relevant time and so on. What shall be done with a person in that moment, in that time? What usually do courts? Usually courts let them go. There is Article 5 of the Convention. And no, I know. I'm just asking what would you have done. I would not have violated rights of a person. Okay, thank you. I've got your point. Okay. Immediately, from the very beginning, I would like to mention that that we have received a request from Automaidan. Have you read it? Yes, I read it yesterday at 9 p.m. I saw it yesterday at 9 p.m. So I just read it through very lightly. I will mention that it's quite a big request from the Automaidan, and several issues reflected there have already been discussed right now at the interview. There is information regarding those employers which have already been mentioned, including Elashev and Partners law firm and Barristers law firm. If I may, I would like to answer regarding all those cases very concisely. I have looked at dates. I know what to add there. Yes, please be concise as much as possible. Regarding those cases mentioned in that request or statement of Automaidan, were you in any way engaged, and if yes, how you were engaged in those cases? If not, just no and say go. On the tone of no, I quitted the job 31st July 2018. Second issue, it was regarding the mayor of Dnipro, it was 2022. At that moment, I was not there. And then regarding the Chief Justice of the Supreme Court, it was 2023, and it's a case of high interest from the side of the public. I also familiarized myself with that case, and as far as I know, it's about a commercial case, and I was not involved at all into commercial case at all. So it means that you have not been engaged at all in any of such cases mentioned in the Automaidan request. Okay, thank you. Yes, so because you were not in contractual relations with those law firms. Okay, thank you. It's clear. And regarding the value of vehicles, which was underestimated on the perspective of this CSO. Please provide a general comment regarding the declaration of the value. So that's a private property of my husband. If I had such questions in advance, I would have prepared my answers. Okay, I know that this vehicle was purchased in 2016. So in 2016, his Mazda 6 vehicle was burned fully, so intentionally burned by other people because of his professional activities. So this and all that time I just was using different old cars. It was one of such cars. I don't know what he repaired there. Regarding my older son, he repaired and, as a mechanic specialist at the automotive spare parts station. I don't know how to call it correctly. So it was an US old battered car. So I don't know how he planned his with friends. So that's like automotive spare parts car station, and they specialized at jeeps and other vehicles like this. So it means that your value indicated by you, it corresponded to the relevant condition of those vehicles, and as it was indicated in the documents. Yes, I think that yes. But actually, when I indicated that value, I referred to the documents. So that's not my vehicles. I can provide you more information regarding other vehicles. So this vehicle, which you mentioned, it was in inappropriate technical condition. Yes. Okay. Dear colleagues, I think that's this is all from my side. Dear colleagues, do you have any questions? Please. Madam Iryna, hello. I have a short question to you. Going back to salaries, to income that you have received, not regarding Ilyashov and partners. Yeah, I realize that, yeah, we can dispute on this position, is that you say that it's responsibility of the employer, but it's not only of the employer's responsibility, because you also were in the process. But since April 21, you started receiving income from a law firm Shadrin and Kuzina. And Kuzina, that's you. So here, we don't have this evil employer who doesn't reflect. But April 2021, 10,000 hryvnia. So doesn't correspond to the reality that a lawyer with name, with reputation and authority receives 10,000 hryvnia per month. You know, when we identify salary for ourselves and define which will be the salary for ourselves, we shall be aware whether we'll be able to receive the salary each month. So please give me a short reply. For an external observer, for all people residing here in Ukraine, a person with such a name of yours who have worked in Ilyashov and Partners law firm, leading firm, 10,000 per month, with a small child, yes. You know, so your answer is yes. It corresponds to the reality. Yes, of course. So indeed, you have received 10,000 hryvnia in that law firm. Thank you. Dear colleagues, are there any other questions? Iryna, tell me, please, have you submitted any other declarations, like yearly declaration for that period, a part of the profits that was accrued to you for your work at that law firm? But next year, did you submit declarations for that year? And is it indicated in the certificate or in the report? Yes. Thank you. Dear PCIe members, do you have any other questions?
As I understand it, you've indicated that you can't disclose to us your income derived from certain law firms because you had a non-disclosure agreement. Is that correct?
One.
And did you report that income to the tax authorities?
No, at that moment, as far as I remember, I didn't have an income from individual entrepreneurs. If I had reported on such income, it would have led to my to firing me from that job. Sorry, I didn't stop myself. I didn't want to make such a direct verbal statement.
Thank you.
So we can discuss it theoretically.
Yes, Jessica.
Also, a very short question about the non-disclosure agreement. you made a motion earlier to request an in-camera session for the purposes related to your child, I believe. Did you also consider the possibility of requesting an in-camera session in order to be able to discuss the subject related to your non-disclosure agreement if you cannot discuss it publicly? Did you consider the possibility of making that motion?
Мені треба подумати.
I need to think.
Наскільки я пам'ятаю, угода...
As far as I remember, the NDA agreement is not, it cannot be disclosed either publicly or in private. So I cannot inform.
I'm not asking.
Тексту цієї
So
угоди в мене немає.
I don't have the text of this agreement, with me, I mean.
My question is not whether or not the agreement itself allows. My question is whether you, as a professional lawyer, acting as your own advocate in this situation, considered the possibility of making a request in your strategy and approach to this interview. Did you consider the possibility of seeking maximum transparency through the procedure of a motion to this group?
Я боюсь порушити угоду.
I'm afraid of violating, and I didn't hear the last word. I'm violating the agreement, I think. So please repeat, because we didn't hear your reply. I think that the NDA agreement, is applicable for any session. So
I think that concludes my question.
We're done, Mr. Chairman.
Гаразд.
okay,
Більше питань.
no other questions, yeah?
Добре.
Then,
Пані Ірина, вам надається можливість.
Madam Iryna, you have an opportunity for your final word to approach the Commission members and the PCA members. Please be concise as much as possible, and if you have such needs and wish. Yeah, thank you. I have such a wish, and I think I have reached such a stage. I think I have prepared myself before quite well, and I wish also for the Commission and PCA members to do their job also well, because our country needs good judges, and I would like to see more lawyers and attorneys among those judges. And I wish you fruitful work, because that's your responsibility to do it. Thank you. Thank you for participation in this interview. Thank you. Have a good